So you're all very welcome here to the VBON this Friday. We're going to be hearing from Grace Boland. She's a solicitor and her business is Boland Law, which provides commercial legal advice in plain English. She's going to chat about contracts, why businesses need them, the key terms to consider, including your contract's terms and conditions, and what to watch out for in supplier contracts. So whenever you're ready, Grace, you can take it away.
Thanks a million, Teresa, and good morning, everyone. I actually have a PowerPoint presentation. Will I share it, Alec?
Yes, go ahead. Yeah.
Great. Can everyone see that? Yeah, all good. Okay, yes. Great. It's hard on the Zoom when you're not sure. Okay, can I move it to?
If you put it into presentation mode, Grace, then that'll help you.
Exactly. Yeah, I had the Zoom bar in my way. It's been a while actually since I've done a Zoom presentation. So good morning, everyone. My name is Grace Boland and I provide plain English commercial legal advice for SMEs. And I suppose I'll very briefly talk about my background because I know we're under a little bit of time pressure and with contracts there is a lot to talk about. I trained and worked in AIB for a long time and I was assistant to the General Counsel of AIB. And during that time, I practiced in a wide variety of areas, but it really gave me an aptitude for being commercial. And I think there's nothing better than working in the commercial law to really understand the challenges that businesses face. And I suppose I was always a little bit frustrated with legal advice that I got from legal firms, and AIB was hiring the best legal firms in the country, but it was always very legalese. They weren't particularly great at telling us, at problem solving, to be honest with you. They were great at telling us what we couldn't do, but not very good at helping us overcome the problem that was facing us. So I suppose when I set up my own business, I wanted to do just that. And I wanted to do it for SMEs. I'm an SME and I wanted to help fellow SMEs. You know, corporates know how to use lawyers, they know how to spend money on them, but I wanted to help people who didn't really understand the whole world and the challenges that they might face, and to minimize risks. So that's why I set up my law firm, and I'm in business now 5.5 years, and thankfully all going well. And apologies, I was late. I'm actually in the middle of trying to close a transaction this week. And for some reason, I had this down for 11 o'clock. So apologies again for being late. So this is a very whistle-stop tour. As you'll all appreciate, there's a lot in contracts. So I'm going to give you the highlights, and I hope that it's helpful. And please do ask any questions, and I will certainly do my best to help. So firstly, what are contracts? Contracts lie at the heart of our everyday transactions, be it personal or business. And we don't always realize that. Every time we make a sale in our business, we've entered into a contract. Every time we purchase something, we've entered into a contract, even if there are no written terms. So what is a contract? Effectively, a contract is a promise, or to use another word, an agreement, which is recognized by the law. And your contract can be framed as a contract, as an agreement, as a letter of engagement, as in terms and conditions. It can even just be key terms in an email where you can clearly demonstrate there is an agreement to enter into a contract and on those terms. But whatever way you do it, it is advisable to be very clear on what your terms are. And that is really helpful in trying to avoid disputes at a later stage. And I suppose, look, at when we all set up our businesses, we're understandably focused on sales and growth. We need to generate revenue. We need to understand whether our businesses are viable or not. And we don't, as small businesses, we don't always have the time or money to look after the legal aspects of our business. And that's understandable. And I think even some of the local enterprise offices, start your own business courses, while they're great and really helpful, they actually don't get into the nitty-gritty of what you need to do in terms of protecting your legal risks. So a lot of businesses actually just don't understand the risks that they are running when they set up. But when you do realize that your business is viable, or more often than not, as happens for SMEs, it's when something goes wrong, you suddenly come up against the risk that you've been running in your business, and you realize that actually maybe you should have looked at it, or maybe even thought about it, or how you could best protect yourself. So it is important to ensure, as you grow your business, to ensure that you're clear on the terms and conditions upon which you are transacting with both your customers and your suppliers. And having well-drafted terms and conditions creates a transparent relationship with your customers. And it sets out the rights and obligations you have, and how to deal with issues when things go wrong, because unfortunately, sometimes things do go wrong. I cannot overemphasize the importance of avoiding costly disputes. It is emotional, it is draining, and it can be detrimental for businesses. There was a YouGov survey done in the UK in 2017, which showed that a quarter of the SMEs there had spent between £5,000 and £15,000 on dealing with legal matters in the previous 12 months. That's a lot for a small business. And that's a lot of businesses to have spent that amount of money. And nearly 1 in 20 had spent over £30,000 in the same time frame. But despite that, only 4 out of 10 held less than 10,000 in cash reserves. So it just goes to show that prevention is better than cure, in trying to head off issues, being clear with your customers, and trying, when disputes do arise, trying to be reasonable and put yourself in the other person's position and try and come up with a reasonable solution without having to go down a very costly route. So I suppose it's really important to work out who your customers are. Are you operating in the B2C world, or are you operating in the B2B world? Generally, most of my clients are in the B2B world, but I did want to mention the B2C world just in case any of you are in that space. And the key legislation in that area is the new Consumer Rights Act 2022, which, according to itself, simplified and updated consumer protection laws. And while it did and it didn't, we still refer in parts to the Sale of Goods and Supply of Services Act 1893, and as well as the 1980 Act. There's the Consumer Protection Act 2007. There's also the rights in relation to transacting online, and then there's GDPR. And of course, each industry is likely to have its own specific laws and potentially regulations depending on where it is operating in. So I might move on to B2B, unless anyone has any questions on B2C. No. Okay. So these would be the types of key terms that you should consider including in whatever form your contractor terms and conditions take. So when we look at them, you've got term. So term can be very important, not always, but it can be very important if, for instance, you're providing services. And it's important to be clear on the term. And it's important to be clear on whether it auto-renews or not. And if there are any termination provisions, and what those provisions might be, and what the notice provisions might be. I would always advise clients, particularly where they're providing services on an ongoing basis, to include a right to terminate for convenience, essentially saying that you can supply on serving, for example, 30 days or 60 days written notice to your client. If you do terminate, be careful not to put in a reason. You don't have to give a reason. And I have actually seen some companies get themselves into trouble having provided reasons, which actually on the face of it could have been deemed discriminatory. So if you don't have to provide a reason, don't provide a reason. You're better off to avoid any potential disputes. And in that one, actually, my client ended up having to pay, I think it was almost 20,000 euros because of the manner in which they terminated, albeit they were entitled to terminate. So it's very important to look at what you've agreed in relation to termination and do it exactly as it said. And if your contract includes notices, i.e. any notices under these terms and conditions or under this contract must be served at the address in this contract, or if another address has been included into the contract, that you do serve it properly. If it says registered post, do make sure you send it registered post. If it allows for email, great. But again, make sure you're including these types of terms in your contract so that you know what to do if and when you need to serve a notice. And similarly, in supplier contracts, these are all really important conditions to look out for in supplier contracts. So make sure you're when you're entering into contracts with your suppliers that you're looking out for things like term and termination. Payment terms, obviously one of the most important terms. Make sure you clearly set out how you're going to invoice, how long the customer has to pay you, and specify, and also you should specify that if payments are paid in accordance with the terms of the contract, that is considered a material breach of the agreement. I don't have time to go into the late payments legislation, but there is a note of it on my website. This is something that SMEs actually aren't really aware of, and it comes from EU legislation. The EU was particularly concerned, and I suppose alive to the fact that in the SME world, when they transact with bigger corporate clients, that those bigger corporate clients don't always pay on time, and that cash flow is so important for SMEs that it can have a detrimental effect on an SME's business if their big clients aren't paying them. So they implemented the late payments legislation, which actually provides for the SME to claim a small, now it is small amount in relation to penalty compensation, and also to charge interest on a daily rate on any late payment fees. It isn't something you see SMEs claim often, I think, principally because they don't know about it, but secondly, I think because they're always afraid of damaging the relationship with the customer, and thirdly, because it is so expensive to avail of the court system in Ireland. I would love to see a small business claims court where claims of under 100,000 could be dealt with maybe by a registrar or a judge, and where SMEs could go in and advocate for themselves without having to necessarily go to lawyers and legal advice. But unfortunately, we're not at that stage yet, although it's something I have suggested to politicians on occasion whenever I get the opportunity. But look, it's the late payments legislation. It's something to know about. It's something to maybe use if the relationship is sour. And actually where it works best is where you have a lot of invoices which you can prove are paid late. And I suppose lastly on that point, under that legislation, a counterpart can't force you to agree to payment dates later than 60 days. So if you ever see something like 90 or 120, that will be deemed unfair under the late payments regulations. And you can say, no, 60 days is the absolute max under Irish and European legislation. So don't be bullied into agreeing to anything later. If you do agree, and the counterpart can show that you did agree, then that may then be deemed to have been your valid acceptance, notwithstanding the fact that 60 days should be the maximum. Renegotiation of financial terms. It's a good idea to include a clause here, particularly in relation to circumstance changes. Say, for example, if your cost of your business your employee costs are hugely affected by an increase in the minimum wage or increase in utilities, you want to be able to go back to your client and have the possibility of opening the terms. Or if you have a contract that's for a long term, again, you want to include that you have the possibility to renegotiate the fees on an annual basis. Liability, obviously very important. You really need to try and limit your liability as much as possible. You should only ever agree to be liable for direct losses. If you ever see a clause saying liability for indirect, special, consequential, anything like that, immediately say that you won't agree to that. Those indirect or consequential losses could open you up to liability that you can't even imagine. They could be liability for loss of your counterpart's profits. And they're unquantifiable. And in reality, you know, you're probably not even, if you do have insurance, you're probably not even insured for indirect liability. And it has actually become so common now not to agree to indirect liability that it's not even usually a negotiating point. You just say, no, not agreeing to indirect liability. It's not my company's practice. We never do. We're not insured to do it. And it's not market standard. And it is not market standard in most businesses to agree to indirect liability. In terms of a cap, again, you should always try and include a cap on your liability. Now, what should the cap be? There is no right answer to that question. What you will see sometimes in bigger contracts is that is the cap on the annual fees. You could put in a monetary limit. You could put in a monetary limit of €500, but do try and include a cap. And even including something like €500 might suffice. If someone tries to negotiate it, you could maybe increase it to $750, but you should definitely, it's definitely worth, I suppose, considering the fees and the likely risks of things going wrong when you're considering your cap. A lot of bigger clients will look for annual fees or maybe 3 times annual fees, etc. But it really is dependent on the business you work in, the industry you work in, who your counterparts are. But either which way, try and come up with a reasonable cap. Indemnities. So an indemnity is a promise to pay on the happening of an event. So if you indemnify someone for something, it means that if that thing happens, that you will pay whatever they have incurred in losses for that event. So in terms of indemnity, it's always really important to agree to a fault-based indemnity. Now, what do I mean by that? So you will indemnify your client for your negligent acts or your breach of the contract. And again, I suppose, look, it's just important to read indemnity clauses and make sure that that is included somewhere, that you're only indemnifying in the event that you've been negligent or at fault or you've breached your contract terms. Retention of title, this isn't relevant to a lot of people. It's not relevant in the service industry, but if you work in the B2B world and you are providing goods, it is always worth considering, should you include a retention of title clause in your contracts. In theory, it allows you to retake possession of any unpaid goods. Now, they are a little bit tricky and they can be a little bit legally. If you do need a retention of title clause, it probably is worth speaking to a legal advisor to make sure that the clause as drafted is enforceable. KPIs, if there are KPIs, make sure that they're clear and achievable, particularly if you're the one agreeing to them. And if there are penalties related to the failure of you meeting your KPIs, make sure you're particularly conscious of that and make sure that they are absolutely achievable and deliverable. GDPR, I know Alec has had GDPR experts speak to the group before, but again, it is one that unfortunately all businesses need to consider. As you'll appreciate, on your personal side of things, you don't want anyone getting data from you or misusing data that you have given to them. And I suppose that's maybe the way to look at GDPR, even though I know it can be an administrative and time-consuming endeavor. I suppose if you always put yourself in the position of whoever's data you're receiving when you are treating it, it'll make you feel a bit, more responsible for it and maybe more appreciative of GDPR, even though it tends to send a shiver down our spine. The legislation is extremely lengthy and onerous, and there absolutely could be several sessions on GDPR. But it really is about transparency. It is about making sure that you have a privacy notice of how you deal with personal data on your website, in your business. If you have employees, making sure you have an employee privacy data policy, that your employees are totally clear and transparent as to how you are using their data. If you've got an expense tool in your business that your employees have to utilize, that they know that their data has been shared with the owner of the expense tool, that any data they put into it is going to be recorded by the expense tool. And the purpose for all of that is the recording of expenses for the company's accounts and also for the payment to the employee. So I suppose we don't always think about those kind of technology apps that we use in our business actually recording personal data and employee personal data. So it's thinking about where all those entry points of personal data are, how they're used, how they're retained, and is that all in compliance with GDPR? And then industry-specific terms. Depending on the industry you work in, you might have industry-specific terms that you need to include, or from your own experience. You might have come across a particular issue with a client and you thought to yourself, well, I'm going to make sure I include a term in my contracts to make sure that that issue doesn't come up again, or we avoid having a dispute over that particular issue. Does anyone have any questions on the key terms?
No, that's fantastic, Grace. I think you've packed the 20 minutes in there perfectly well. And,
yeah, thank you very much, Grace.
Oh, am I finished?
Yeah.
I'll very briefly just then talk about supplier terms. As you see, the key terms here, always look out for those in your supplier contracts. But I, in particular, want you to note IT contracts. So even the likes of LinkedIn, IT companies build in automatic renewals into their contracts. So you might think that you've signed up for a year and that you can cancel, once you get to the year. What they do a lot of the time is they put in 3 or even 6 months notices of renewal. So unless you realize that you need to cancel, say, your LinkedIn subscription 6 months in advance, at least 6 months in advance, it'll auto renew on the 12 months. And all the IT companies are at that. So you just need to be really careful when you sign up to any of those agreements. Make sure you check what the notice provision is and that you diary it so that you can consider in 5.5 months, actually, am I getting value for this, or do I need to cancel my subscription? And I suppose, look, when you get supplier terms, always see whether you can try and negotiate them to be a little bit